Yes, Mr.
My Lords, I appear on behalf of Mohammed Adil, the appellant in this matter, leading Savannah Laurent, my learned friend Martin Ford, King's Counsel, leading Peter Mount, act on behalf of the General Medical Council. My Lords, in essence, this is a claim about the freedom of expression of a doctor, and in particular his freedom to engage in medical, scientific and political debate. As Lord Bingham put it in the Crown against Shaler, cited in Miller, which is in the bundle, modern democratic government means government by the people. There can be no government by the people if they are ignorant of the issues to be resolved, the arguments for and against different solutions, and the facts underlying those arguments. As John Stuart Mill put it succinctly in On Liberty, there is the greatest difference between presuming an opinion to be true, because with every opportunity for contesting it, it has not been refuted, and assuming its truth for the purpose of not permitting its refutation. My Lords, it is the claimant's case, the appellant's case, that is exactly what the Tribunal and then the High Court on Appeal have done. They have sanctioned Mr. Adil on the express basis of opinions and facts that he has stated, questioning and speculating on the research into a product, the COVID-19 vaccines that had not even been released in 2020, expressing views that were not, as is agreed, widely held by other medical professions, a restriction on the expression of opinion much more far-reaching than on doctors treating patients under the well-known Bonum and Belido principles, who may use any treatment supported by a reasonable body of professionals. His views contradicted government advice, and that, as I will turn to in due course, is a key reason for his suspension and his discipline. He expressed opinions about wider geopolitical and public health that the Tribunal found, and your Lordships may well agree, but as I will add in due course, not the point in my submission, without any consideration of evidence other than his statements, that they were conspiracy theories and that Mr. Justice Swift found were outlandish and not legitimate. A term in my submission that is deeply concerning for a judge of any court to make when it concerns political, medical, scientific and/or almost any other views. I have some overarching points before I develop this appeal, if I may. Firstly, in terms of the nature of this appeal, it is not a case which demands a high degree of deference to the decision of the Tribunal in my submission. The facts were not disputed, and the court is in as good a position as the Tribunal to determine the proper construction of statutory guidance, and indeed, and of course, the common law, particularly in the context of an Article 10 appeal. In ground one, there is no clear legal framework in my submission to allow the interference with Article 10 rights to be considered to be permitted by law. In particular, no authorities cited by the GMC support the contention that a regulatory body can restrict the expression of opinion on the grounds of public health without a provision of a law that is a basis for doing so. The professional regulatory cases relied upon by the GMC in which interference with Article 10 was permitted are exclusively cases in which the speech was said to cause offence and or be discriminatory and or breach other persons' rights to reputation, relying on express provisions in the code for barristers, doctors, social workers and other professionals. Ground two, Article 2.1 in my submission requires an intense focus on the need for the exception. That is to say, the need, the necessity, as the convention puts it, for restrictions to protect, in this case, public health. Are they necessary in a democratic society? In my submission, Mr. Justice Swift evaded this question almost completely. There is in my submission a high degree of protection for speech about matters of importance in public debate, reiterated on many occasions by your Lordship's bench and others in this country and elsewhere, as much scientific and medical as political, and for the state including through a public body such as the GMC, or indeed the courts, to discipline a doctor for contradicting public health advice breaches the state's duty of neutrality, as would this court were it to uphold it, in my submission. In all the cases before you, only one, Hertel in Switzerland, which is tab 2 in the authorities one I'll come to in due course, concerned interference on the grounds of public health. And in that case, the Strasbourg court found, even in relation to an express legal prohibition on speech on the grounds of public health, the effect of the injunction was thus partly to censor the applicant's work and substantially to reduce his ability to put forward in public views which have their place in a public debate whose existence cannot be denied. That is to say, the existence of those views.
Can I just go back a moment,
My lord.
Mr. Hall? You said that that to sanction your client breached the state's duty of neutrality. Can you just explain that?
Yes, and I will, and I have will develop that point in detail in due course. But essentially, the decision by Mr. Justice Swift was that the reason that he could be confident that the tribunal made the right decision, albeit for the wrong reasons, which is essentially what he's found, was that these views were outlandish conspiracy theories and not legitimate. What is legitimate is an important question, and it puts into frame whether or not that is the state, including through the courts, restricting views on the basis of what it considers to be legitimate, which is a paradigm example of what the courts should not do, as is set out by the Strasbourg court in the case of Bessarabia, the Bessarabian Orthodox Church. We'll get to that case in due course. This is an important part of ground 2 rather than 1, but I'll turn to it in due course. And my fourth overarching point, final in respect of ground 2, is that it would be disproportionate to impose an interference with freedom on the expression of opinion as great, or even as the restriction on doctors when treating patients, and that's the Belido-Bolam point, which I'll develop in due course. And finally, my lords, in respect of ground 3, there was in my submission, as Lady Justice Andrews found was at least reasonably arguable, a clear failure by the learned judge below to consider proportionality. And in my submission, the case law does support my contention on behalf of the appellant, which is that it is appropriate for the court in determining proportionality of a sentence to consider the time that a doctor or another professional has served, as it were, not in the strict criminal sense, not in an absolute sense, but it is a factor to be taken into consideration and should have been. My lords, if I may first...
Sorry, just in relation to that point, when you talk about proportionality there, you mean Article 10 proportionality?
I do. And I mean proportionality generally, but in particular Article 10 proportionality. And remember that the sanction, of course, is as much a restriction on a professional's ability to speak publicly as is the fact that he is dismissed. It isn't sufficient just to say, well, it's proportionate to have a sanction and then ignore proportionality. And that's supported by Mr. Justice Lewis, as he then was in Powers, which is in the main bundle, and in fact both of these authorities are, and indeed by your lordship in, I think I'm not wrong, in the case, I'm so sorry, if I may turn to it, in the bundle.
No, it's all right. You can
come
come
back.
back.
I'm so sorry.
Speaking for myself, I'd like a little further assistance on that, because I can see that it might be said that if you get to ground 3, and therefore what he has been doing is a legitimate interference with Article 10 rights, then a sanction which is imposed for that is a sanction for conduct which is lawful.
Yes.
And I'm not at the moment sure why the nature of that sanction then engages Article 10, because he's being sanctioned for not being able to do something which he's not entitled to do.
Yes.
So that I'm speaking myself. I may need some help on that.
I will, I hope, provide it, my lord, in due course. But if I may turn firstly to the underlying facts. Of course, your lordship's well familiar with them. They're set out at paragraphs 9 to 19 of my skeleton argument at page 22 in the I think tab 1 in the appeal bundle. But it might be helpful if your lordships turn up rather than that. Page 136 at tab 10 in the appeal bundle, which is the determination on the facts, in fact 135, where your lordships will see the way in which the GMC before the tribunal puts the charges, and your lordships will see at page 2 are the relevant charges relating to this matter. And there you will see all of the uncontentious pronouncements made by Mr. Adil, and the basis for the charges is at paragraph 3 and 4.
So sorry,
Well,
which
4
page?
really, which is
page?
page 137, my lord. So sorry. Your actions as referred to in paragraph 2, A, undermined public health, B, were contrary to widely accepted medical opinion, and C, undermined public confidence in the medical profession. And I addressed this point at paragraph 18. I just made, if I may just turn to that in my skeleton argument.
Can I just ask you a factual question before we get to paragraph 18?
Yes.
In your paragraph 10, you say that he was contacted and requested to take down the videos, which he did. Is it common ground that he also then uploaded further videos? Oh, right.
It is. I have dealt with this almost, not in parenthesis, actually in a footnote. It didn't appear to me to be contentious below, but if the court finds that requiring the removal of the video was a disproportionate interference with his Article 10 rights, or more pertinently, if it wasn't even permitted by law, if your lordships are with me on ground 1, then requiring the video to be taken down, it would follow, in my submission, was also a disproportionate or unlawful, potentially, interference with his Article 10 rights. There was no argument on this below. I took it to be uncontentious, but I'm happy to develop that point in due course.
But that doesn't sweep away paragraphs 5 and 6, does it? Because one of the things of which complaint was made was that he told the responsible officer that he would take them down, and he didn't. That was the finding.
Yes.
And that's quite separate from whether the request was a sound one or not. It was simply not doing what he said he would do when asked to do it by his responsible officer.
Yes, it is. May I come back to that point, my lords?
Yes,
Because I appreciate
and the point my lord raised about taking them down when he was requested to do so in paragraph 10 of your skeleton. I think the finding of the tribunal was that he did not take them down.
I accept that. I apologise.
So we need to correct paragraph 10.
Yes, I think which he did, but it's not complete because it's right. It's not contested as a matter of fact. None of the facts in this case are contested. I did make that clear, please.
Thank you.
Lord, may I turn to paragraph 18, which is essentially where I summarise the way that this is put in my submission.
I'm sorry to keep holding you up, but
of course. No.
Can I just, paragraph 13 deals with the position in relation to interim suspension.
Yes.
And it's dealt with quite briefly, and I wasn't entirely sure I'd understood exactly what happened. Have I understood that there was an order of the interim tribunal on the 1st of June of 2020, which suspended for 12 months based on conduct?
Yeah.
Then there was a review 20th November 2020, again presumably by the tribunal, which involved clinical and health issues and maintained the suspension.
I'm so sorry, I missed the last.
It included.
There's a chronology. I don't
There
know
is a
whether it's.
chronology.
I hope it's agreed.
It is agreed, I think.
It is, but I'm not sure that in relation to interim suspensions orders, it gives us any more of the.
It may be
of the
that
detail.
only because this might cause some delay. It may be that we can clarify that point for your lordships.
But perhaps you could provide the orders. What I'm particularly interested in is, as far as I can see, there came a point in January of 2022 in which the tribunal removed the suspension and attached health conditions.
That's right.
And what were the health conditions? Don't worry if you haven't got it to hand.
I haven't got it to hand.
Speaking for myself, I find it very helpful just to have the various orders so that I can work through them.
And I have a feeling that the health conditions relate to the separate matters, which are not before your lordships. But I think that's the case, but we can certainly clarify that to the lordship.
Yes.
No.
And then the other thing I was interested in was what he had been doing throughout the period of
there was
suspension.
Some medical work, very little, and I understand that really as a result of these proceedings, albeit I can't say the direct result of the suspension, that he wasn't able to continue his surgical position at a hospital for that reason. But so the total period of suspension has been very lengthy because of the appeal, essentially. There is this difficulty for a doctor or surgeon who appeals, which is that they are their suspension is, unless if there's immediate order, their suspension carries on from that moment until the determination of the appeal. Indeed, it only starts at the beginning of the appeal. Now, that's something that it may well be thought Parliament should rectify, but obviously not before your lordships. But that is why the proportionality point and taking into account the previous suspension is so important. As my Lord Mr. Justice Dingemans, as he then was, found in the case in Camberova. I'm most grateful.
I hadn't picked this up. That the running of the suspension period from the expiry of the appeal process, that is obligatory, is it, under statute?
It is.
Which section is that? Again, don't worry if you haven't got it to hand, but perhaps you could let me know.
Another matter.
So the net effect is that, suppose for these purposes the appeal was dismissed, he would then, when the judgment is handed down, start his 6 months?
Yes, that is the net effect.
Thank you. And just coming back to what had been happening prior to the decision of the MPT, he'd been practicing, had he, in this country when the suspension was lifted, or abroad? I noticed that he said during the mitigation process that he'd been abroad for 2 years. He'd been practicing in
Pakistan.
where? In Pakistan.
But I think rather than answering that, if I may deal with that point at a later stage.
Yes, do.
That can be looked into as I'm on my feet.
Again, speaking for myself, I find it very helpful to have that information. Thank you.
Sorry not to have that immediately to hand.
Right, so I interrupted where you were going.
No, not at all. So I summarise, going back to the general introduction to the facts, that this is what I submit is the case. In making its findings, the tribunal took into account the unprecedented medical and social context in which Mr. Adil's comments were made. Might be suggested that that's in itself a position on fact which is not accepted by everyone. Namely, that the public were able to view television daily bulletins from the government and senior health officials explaining the rationale for lockdown restrictions. And of course, I pause to note that that was hardly uncontroversial in itself. And official data, again, not uncontroversial. And that the scale of the confusion and uncertainty at the time created general reliance on the information and advice, and I interpose, and it would appear opinion, being supported by the people, the public, could trust. And when I say opinion, opinion is specifically referred to by the tribunal. The tribunal again relied upon the requirement to comply, their words, with, I put it, controversial restrictions, and the reasons compliant were required. Well, in other words, the tribunal took into account positively the fact that the state had said there are these restrictions. This is why there are restrictions. This is why we say this is an unprecedented public health emergency. Unquestionably, it was an unprecedented response to it. Query, was it an unprecedented emergency? And these are all, in my submission, the position the state, in its broadest sense, took over the lockdown with which Mr. Adil was at odds. And yes, it is right to say Mr. Adil spoke much more than that and said things that perhaps few people will agree with. That might perhaps be the case, but that was the nature of the decision, and that was why the tribunal came to the decision. And in due course, I'll take your lordships to, in ground two, to the principle that the question is the necessity of a restriction on public health grounds. And that, in my submission, is important to bear in mind how the tribunal came to its decision, because while, of course, it is right to say that it's the outcome rather than the means of the decision that matters, when Mr. Justice Swift said that opinions were not legitimate, on what basis did he reach that decision? And is it the case that, in fact, if you look at it, there is very little basis to see how he did, no explanation as to what is legitimate, and really one has to go back to these findings by the tribunal to discern what a legitimate opinion is. Is it the case, in effect, that the legitimate opinion in a global pandemic, as it is declared to be, and the response to the pandemic declared to be and asserted to be proportionate and necessary, is it the case that any opinion contradicting that is somehow not legitimate? Now, I appreciate that Mr. Justice Swift took some steps to distance himself from some parts of the finding. That is to say, that widely held medical opinion wasn't a requirement that one must follow widely held medical opinion. That is right. But he went on to find that clearly, in this case, outlandish opinions, illegitimate opinions, conspiracy theories, whatever those might be, are somehow illegitimate. And that's what's at contention. Is it contention here? Relevant, my lord, so yes, if I may turn now, because I'm going to come back to that, but if I may now turn now to the deference to be given to a tribunal, it may be that I need not take too much of your lordship's time on that. The respondent addresses this point in paragraph 20 of their skeleton argument, which is at page 51 of the appeal bundle. And the propositions that set out, or the test set out, is uncontroversial, but save to this effect, that it is quite clear that the cases relied upon by the respondent show that the degree of deference will vary and is very much less when the court is not reviewing decisions of fact. I have 4, or in fact 5 cases to take your lordships to. I need not take them to your lordships in the bundle. It may be that references would be sufficient, but of course I'm able to do so if your lordships wish. The first 2 are actually in the supplementary authorities bundle, tabs 5 and 18. And the first of those is Gupta, which is at paragraph 10, page 66 in the supplementary authorities bundle. and your lordships will see in the weekly law report of this that this is a case of medical practitioners. It concerns erasure from the register, and Lord Roger, in his judgment, at paragraph 10, as I say at page 60, in fact, but it's actually 68, I find, as I look towards it. The decisions in Gauche and Prace do indeed emphasise that the board's role, as it then was, the Privy Council, now the High Court and on appeal to your lordships, is truly appellate. But they also draw attention to the obvious fact that appeals are conducted on the basis of the transcript of the hearing, and that unless exceptionally witnesses are not recalled. And he goes on to find, in all such cases, the appeal court readily acknowledges that the first instance body enjoys the advantage, which the appeal court does not have, precisely because that body is in a better position to judge the credibility and reliability of the evidence given by the witnesses. Now, of course, that doesn't apply here. In the same bundle, in the same volume, Lord.
It doesn't apply in strict terms, but
No.
in relation, for example, to the question of insight, when one comes to sanction, the tribunal has an immeasurable advantage over us in forming its view, having heard submissions from Mr. Adil over quite a long period of time.
And other witnesses. And I'm not content, I wouldn't dispute with your lordship that when it comes to sanction, a higher degree of deference might be played, although that's obviously premised by the question which didn't trouble and wouldn't have troubled the tribunal about what one does in an appeal if there is a substantial period of suspension that will not be taken into account. But I certainly agree that when it comes to a professional disciplinary tribunal, their opinion on insight is obviously relevant and should be given considerable deference. I wouldn't dispute that for a moment. I'm talking about the factual findings and the extent to which that engages Article 10 in this instance. Bauer-Garber, the case of Bauer-Garber, which is at tab 18 in that same bundle, which is a decision of the Court of Appeal. And the judgment is of the entire court led by Lord Burnett, deal with this issue at paragraph 63, which is at page 358. And effectively, they're upholding Bowen and the Secretary of State for Justice, paragraph 65, Lord Justice McComb. The appeal court's approach will be conditioned by the extent to which the first instance judge had the advantage over the appeal court in reaching his decision or her decision. And paragraph 64, the judgment of Lord Justice McComb and Bowen, when the appeal, so I'll just identify that. Yeah, essentially, 2/3 of the way down. So, well, just over half the way down. So, for example, it has traditionally been held that absent an error in principle, the Court of Appeal will not interfere with the exercise of discretion unless the judge was plainly wrong. On the other hand, where the process involves a consideration of a number of different factors, all with a band on the circumstances, as was Justice Hoffman put it in Re Graydon, generally speaking, the vaguer the standard and the greater number of factors that the court has to weigh up in deciding whether or not the standards have been met, the more reluctant an appellate court will be to interfere in the trial judge's decision.
This is slightly off the point, isn't it? I thought we
yes, perhaps.
The deference question is to what extent should a court it doesn't matter whether it's the High Court or this
Yeah.
court, defer to a professional regulatory body on what conduct brings the profession in disrepute or is calculated to undermine the public's trust in that profession. I thought that was the issue
Yes.
you were
It
addressing.
is, and my lord, it's better encapsulated in the judgment of Sawati and the GMC. If I
Well, before you leave that,
Yes.
you've got paragraph 67, which I think captures the point, my lord.
yeah, I'm so sorry, I've turned the page back now. Yes. Yeah, and I fully accept. So I see that essentially the force in the case of the specialist adjudicative body such as the tribunal, and that is developed in more detail in Sawati, which is in the second supplementary bundle. Paragraph 49, page 616. In fact, it's that paragraph starts on the previous page, 615, my lords. Mrs. Justice Collins Rice, I found there another important factor in the degree of deference is the expert composition of the tribunal, where the appellate court lacks the tribunal's professional expertise. It must approach a challenge that the tribunal has made wrong decisions about what is necessary to protect the public and maintain public confidence and proper standards in the profession with a degree of diffidence. But there may be matters such as, the ladyship puts it, dishonesty or sexual misconduct, where the court is likely to feel that it can assess what is needed to protect the public or maintain the reputation of the profession more easily through itself, and thus attach less weight to the expertise of the tribunal. And while, my lord, pausing to make some reflections about those citations, while it is of course right that that isn't before your lordship in this case, those examples, and while it is also right, of course, that these comments by Mr. Adil in interviews concern matters of medical matters and scientific matters, albeit also political matters. In this case, one also has the Article 10 considerations to consider, and where it comes to the protection of human rights of that importance, protected not only by the Convention, but of course also by Section 12 of the Human Rights Act, which requires this court and others to have particular regard to freedom of expression, then this court is in as good a position, in my submission, to make that judgment, or at least the degree of deference to which this court, your lordship's court, should have to that decision need not be as high, and I would put it could be considerably lower than that tribunal. These all, of course, relate much more to ground 2 rather than ground 1.
Yeah.
And I wonder if this is a convenient moment to turn to ground 1, but it may be your lordship have some questions about those submissions and those cases.
You said there were 5 cases you wanted to refer us to. Do you want to just give us
I'll
the,
give you the
references to the
I will,
others?
indeed. Thank you. So the other ones are Nandi and the GMC, which is supplementary bundle tab 6, and in particular paragraph 33, which is at page 83 of the supplementary bundle. Khan and the General Pharmaceutical Company, which is tab 11 of the supplementary bundle, paragraph 36, and page 168.
Thank you.
My lords, turning to ground 1, which is whether or not the Medical Act or the guidance, or indeed common law, provide a sufficient legal basis for the sanction put upon Mr. Adil. As Lady Justice Andrews noted when giving permission on paper, while these grounds are disjunctive, much of the submissions on ground 1 bear alternatively in my submission on ground 2. That is to say, your lordships may find, and of course I will seek to persuade your lordship otherwise, but your lordships may find that there is a sufficient legal basis. But the vagueness of that legal basis and the lack of authority and the inability of a doctor or surgeon to understand what tests he was facing is, in my submission, a relevant factor when one comes to assess proportionality, something I will develop more in relation to ground 2. If I may turn first to the proposition at paragraph 35 of, and I'm sorry, this is the principal authorities bundle, tab 2.
Tell us what the principle
Yes.
is for which we're looking at tab 35, and then we'll get there.
Yes, the principle is the degree of clarity that the court, of which the court must be satisfied before imposing
So which authority are we looking at now?
it's, I'm so sorry, Hurtle and Switzerland, tab 2 of the main authorities bundle.
Thank you.
And it's at page 82. Unfortunately, this report has an extremely confusing paragraphing, so it's quite difficult to work out what to what. It's page 82, and your lordships will see there, the court reiterates that a norm cannot be regarded as law within the meaning of Article 10.2 unless it is formulated with sufficient precision to enable the citizen to regulate his conduct. He must be able, if needs be, with appropriate advice, to foresee, to a degree that is reasonable in the circumstances, the consequence which a given action may entail. Those consequences need not be foreseeable with absolute certainty. Again, while certainty is desirable, it may bring in its train excessive rigidity, and the law must be able to keep pace with changing circumstances. Accordingly, many laws are invariably, inevitably couched in terms which, to a greater or less extent, are vague, and his interpretation and application are questions of practice. And then,
what was the law that Mr. Hurtle had contravened?
it was a law that,
And I see the facts at the relating to dangerous microwave ovens, but what under what law was he convicted, if that's the right word?
I may turn to that, my lord. So the judgment starts with the facts, and there's a lengthy citation of the article at pages 57 onwards, and then it addresses the legal framework.
It was a competition provision, wasn't it?
It was.
It was an element of competition law.
But particularly relating to what comments could be made about
On that page 83. So
page 83.
36. We just read on from the highlight.
Yeah, thanks. Yeah, I'm very grateful to my own friend. Yeah, section 2, I'm so sorry, paragraph 36, page 83. In the instant case, section 2 contains a general, the Federal Unfair Competition Act contains a general provision in which what's defined as unfair or illegal, not only any commercial practice, but any conduct which is deceptive or in any other way offends the principle of good faith and affects relations between competitors or between suppliers and customers. And it includes in particular where a person denigrates others or the goods, work, services, prices or business of others So one can see immediately the obvious application of that, and the Strasbourg court found in that case, unsurprisingly, your lordships may think that that was a provision of sufficient clarity, at least when one as a professional has the benefit of legal advice, which is a relevant consideration. Very far away in my submission from this case, where there is simply no provision, I submit, I'll come to that in due course, but there's no provision that could clearly say that the expression of opinion about any matter could contravene the guidance. In the first tab in that same bundle is the Sunday Times case, another Strasbourg authority, Sunday Times against the United Kingdom, and at paragraph 49 of that case, the Strasbourg, which is at page 28 of the main authorities bundle. 29, I'm so sorry. In the court's opinion, the Strasbourg court's opinion, the following is 1979, but a case that's been referred to extensively since, including by Mr. Justice Swift in the judgment below. In the court's opinion, the following are the two of the requirements that flow from the expression prescribed by law. First, the law must be adequately accessible. Secondly, a norm cannot be regarded as a law unless it is formulated with sufficient precision. And they went on, these consequences need not be foreseeable with absolute certainty. Experience shows this to be unattainable. Certainty is highly desirable. It may bring in train excessive rigidity. And so the question is how much clarity, my lords, is needed before something can be considered to be law. The GMC relies in their submissions on the case of Oy and Finland, which is another Strasbourg authority, of course. That's tab 13, starts at page 286 of the main authorities bundle. And your lordships will see, wait, your lordships, turn that up. Yes, your lordships will see from the summary that this was a case about the curiously Nordic Scandinavian practice, perhaps I should say, of revealing everyone's tax records, and that compatibility of that with data protection regulations. But the detailed facts perhaps need not concern your lordships. But at paragraph 148, which is page 328 of the authorities bundle, they address the question of foreseeability in the highlighted passage. As regards the foreseeability of the domestic legislation, in the absence of a provision in the domestic legislation explicitly regulating the quantity of data that could be published, and in view of the fact that several media outlets in Finland were also engaged in publication, the question arises whether the applicant companies could be considered to have foreseen that their specific publishing activities would fall foul of the existing legislation. And they go on at the next paragraph, 149. For the court, the terms of the relevant data protection legislation and the nature and scope of the journalistic derogation on which the applicant company sought to rely were sufficiently foreseeable, and those provisions were applied in a sufficiently foreseeable matter. And they go on to explain why. The Personal Data Act transposed the Data Protection Directive, the EU directive, into Finnish law. According to the Act, the processing of personal data meant the collection, recording, organisation, use, transfer, disclosure, storage, manipulation, etc. of personal data. Reasonably clear from that wording that there's a possibility that the national competent authorities would one day arrive at the conclusion that the database established for journalistic purposes could not be disseminated as such. And it's on that basis that they found that there was a sufficiently clear legal basis. And you'll note in that case that the journalists did have a database. There was legislation regulating it. It may well be, and we'll come to advice in a moment, that they would have needed legal advice, but they were journalists, and they can be expected in the course of their professional life to rely upon that legal advice.
But what, Mr. Hall, what you're complaining of is that the allegation that your client's conduct tended to undermine or damage public trust in the profession is too vague.
It's not so much the allegation, it's the legal basis for the allegation, my lord. It's the basis on which the General Medical Council can put a charge that is framed relying upon the exceptions, relying upon the public health exception, as they must. Because as Lord Hoffman said, I've not cited it, it's actually in my skeleton, I think, if there isn't an exception, it's a trump card, as he put it in Central Television. In the Central Television case back in the 1990s, and that's obviously right. So there is a reliance on the public health exception, and the way in which that legal prohibition on speech that offends or that potentially puts at risk public health must be framed with sufficient particularity. So it may well be that the charges would be very particularised. The complaint can and is made about the way the charges were framed in this case, but there may well be very particularised charges. But if they don't have a sufficient legal basis, if there isn't sufficient clarity for those charges to be put, then they must fail.
Well, I quite see. You said it a couple of minutes ago that some of this feeds into your Article 10 argument on round 2, and I can entirely see how it does, but I don't at the moment see why ground 1 has separate merit. Given, I mean, you're not saying, are you, that a charge that conduct by a professional undermines public confidence in the profession or brings the profession into disrepute? There are various formulations. Is ipso facto fails the test of legal certainty?
No, but no, I don't. But insofar as it relates to the freedom of expression, and insofar as it relates to one of the exceptions, the conduct that is prohibited, it must be sufficiently clear, from the statute and or the case law as to what conduct is prohibited. And it may be that that's with legal advice. And in fact, this is a convenient moment if I may distinguish that potentially from Article 8 cases.
So I'm having a bit of difficulty in reconciling your answer.
I'm so sorry, Lord.
Saying no, and then you seem to be saying yes. I think my Lord's question was, are you saying that the fact that the conduct is bringing the profession into disrepute or undermining public confidence in the profession, are you saying that that fails the test of legal certainty?
When it comes
to which you said, no, you're not saying that, but yes, it does if you don't know what conduct constitutes that kind of misconduct. Is that your point?
not in general terms, but when it comes to freedom of expression, yes. So the reason that we're here is because of Article 10 and because of the way the Strasbourg Court and the domestic courts have interpreted the obligations on the state in respect of Article 10. That doesn't apply directly, at least, where Article 10 is not concerned. So yes, of course it is right that it may be that professional bodies can have a wide latitude of deciding what undermines confidence in the profession in general terms. And an example of that, for example, was the Fish 10 case, in which my own friend Mr. Mount appeared, and that's at the main authorities bundle at tab 16. That is an Article 8 case, and my submission, Article 8, is also a different category to Article 10 because of the way in which Article 8 is put. And there isn't a sufficient, if I may develop that point, you may wish me to turn up the particular articles, but if I may, they're in convenient places to find them is tab 18 in the full starter case where Article 8 is cited. It's obviously the other articles are cited in my scale and arguments, but if it gives you a good opportunity at page 486, one sees.
I'm sorry, it's my fault. Just so I understand where I'm going. It is your submission that it's never sufficient to meet the prescribed by law requirement in Article 10 to do no more than identify that the conduct will be misconduct because it brings the profession into disrepute and or undermines confidence in the profession.
Yes, absolutely right. And that may not be the case in non-Article 10 cases, and those have to be decided by different. Article 10 simply doesn't come into it. And different considerations again apply when Article 8 is concerned, for reasons I'm going to come on to. But when it comes to Article 10, because freedom of expression is engaged, the Article 10.2 can only be relied upon if there is sufficient, if the regulations are prescribed by law with sufficient certainty and sufficient foreseeability.
So if, for example, a consultant published widely that he thought all of his colleagues in a particular department, which wasn't his, let's say he's a colorectal surgeon, if he said all the cardiology department at this hospital is staffed by doctors who are entirely incompetent and who are prescribing drugs which you shouldn't take, so don't do so.
As it
that doesn't meet that couldn't be charged as misconduct for bringing the profession into disrepute.
It could, because there is different statutory basis. There's a different statutory basis for the protection of reputation, and indeed this is exactly the point that I developed in my scheduled argument. I'm going to develop in due course about the Khan case. That is essentially not the exact facts, of course, but let's turn to that if I may. It's tab 10, tab 12. In the main authorities bundle. It concerns a barrister, and it concerns what's described as roving room gossip, but in the worst sense of the word. And in that case, Mr. Khan explained loudly, or at least sufficiently loudly for other barristers to hear in a roving room, that a client of his had accused another barrister of various criminal activities, and the High Court, in reviewing the decision of the bar, the tribunal, in the case of the Bar Standards Board, brought. So the background you can see in, my lords, in paragraph 7, there's an extensive citation from paragraph 257. And you need not, essentially, what was alleged was harassment. This was ongoing charges. There was a question of the extent to which it was in the public domain. Mr. Justice Warby decided it clearly wasn't, at least insufficient, on a sufficiently clear basis. But I note that the court, in coming to that decision in Khan, that was misconduct, were able to rely on specific provisions in the Bar Standards Board Handbook. And if one turns to particularly paragraph 63 at page 200, that's not right. So paragraph 63 at page 279, you will see, your lordships will see 4 lines down, three lines down, in my judgment, a, if not the central function of the Bar Standards Board's regulatory regime is the protection of the reputation and rights of others. Core Duty 5, which the Tribunal found to have been breached in this case, is expressly aimed at maintaining the public confidence in barristers and the profession generally. That is a reputational matter. And I could go on, but your lordships will see how it is put by Mr. Justice Warby in that case.
Well, that's based on a specific identification of reputation of others in
Yes.
this statutory framework.
Yes, exactly.
There isn't that in the Medical Act or the guidance. So in my example, do you say
Well,
prescribed by law?
I'm not sure that's right about the medical, well, certainly about the Medical Act, but in terms of the guidance, the statutory guidance, and what Mr. Justice Swift found one should refer to, we'll come to whether he's right about that. But we perhaps can check that over lunch whether there is a reputational standard. But that is exactly what one would expect to find in a prescriptive basis standards for professionals, and in that case, that was the reason why Mr. Khan was disciplined, and that was a central reason why it was found to have sufficient foreseeability. I don't think, to be fair, my lord, I don't think this point was raised specifically in that case. It was a proportionality case.
No, I'm just testing how far your argument goes, and speaking for myself, I'm not sure I see a bright line distinction between the reputation of other doctors and the reputation of the profession as a whole.
Well, but it's what you mean by the reputation of the profession as a whole, because the professional reason why the regulators will regulate conduct which affects the reputation of others is because that in itself affects the reputation of the profession.
Right.
But what affects the reputation of the profession is a much more general question, and it's a question that should and be answered in respect of freedom of expression cases with sufficient clarity and foreseeability to discern not merely that speech may affect the reputation of the profession, but that opinions and statements of facts and statements of contentious medical, political, scientific issues are themselves capable of affecting the reputation of the profession, notwithstanding the high protection that the courts have always given to the freedom of expression. It's for that reason that there is a need, and it's not I mean, as I made clear, I hope fairly, the authorities don't say it's necessarily a bright line. It's simply that there must be a sufficiently foreseeable basis for that. And in my submission, the statements of opinion and assertions of fact and assertions of geopolitical matters, which might be highly controversial, although I note that so are religious views that are expressed with relative freedom almost complete freedom by medical professions, and so are all sorts of views. It's that clarity that is needed in Article 10 cases, and indeed, when one turns to reputation and statements that are purely aimed at or have the effect of undermining the reputation of others, and that is certainly treated, and I know this is probably a ground 2 point more than a ground 1 point, but that is certainly treated with a far lower protective sensitivity by the courts, quite rightly, than is statements about political and matters of public affairs, which have a far higher basis of protection. But and that also is why that clarity in my submission is necessary, because it is simply not foreseeable. There's no case law, so I've not been shown by your lordships, haven't been directed to any case law where there was a successful disciplining of the medical profession simply, other than in the court below, of course, simply on the basis of political, scientific, and medical opinion, under engaging the public health exception. Now, that's not to say that's all possible, but that also goes to the question of foreseeability, because as I'm about to show, if I may, that the reliance on advice point, which is an important part of Malone and Friends' arguments, actually doesn't go in their favour at all. And perhaps this will is a good moment to turn to that. So, Chalvy in France at tab 5, for example. Chalvy in France, as your lordships turn to it, so the facts are in the European Human Rights Reports from page 128, concerned journalists convicted of criminal libel for asserting that individuals were connected with Klaus Barbie, who your lordships may remember was the notorious Nazi who was convicted in, I think, the 80s and 90s of war crimes in Lyon. And in that case, at page 143, paragraph 43,
Paragraph
43, the court's assessment, page 143 and paragraph 43. This is where the reliance on advice comes in, although it's also touched on in other Strasbourg cases, actually. The court reiterates that a norm cannot be regarded as a law within the meaning of Article 10.2 unless it is formulated with sufficient precision to enable the system to regulate its conduct. That, of course, repeats what the lordship said, what the Strasbourg court has said. Accordingly, and the last sentence of that, accordingly, many laws are inevitably couched in terms which, to a greater or lesser extent, are vague. The scope of the notion of foreseeability depends to a considerable degree on the context of the content of the text in issue, the field it is designed to cover, and I pause there, field it is designed to cover. The simple statement that the reputation of the profession can be affected by conduct does not cover the field explicitly or otherwise of freedom of expression, unless one can say it covers everything and that must include speech, but it doesn't specifically and foreseeably cover that. And they go on, and the number and status of those to whom it is addressed, a law may still satisfy the requirement of foreseeability even if the person concerned has to take appropriate legal advice. But what was that? In that case, there were 3 Court of Cassation cases, 3, not 1 but 3, on which legal advice could have been sought and obtained by journalists in the course of their professional activities. So not speaking on YouTube, as Mr. Adil was, not making a tweet, but actually writing a report in a newspaper supported by, one would understand, the newspaper's resources. They could have obtained legal advice. Had they done so, they would have found those Court of Cassation cases. And that would have informed them that with clear precision, what they were doing was the offence, or was capable of being the offence of criminal libel. And the context, so the context there is set out at paragraph 46, and your lordship will see the 3 Court of Cassation cases in 1956, 78, and 1989. And remember, of course, this is a 2004 authority. Not that that matters particularly. So part of the foreseeability of a restriction prescribed by law is that the prescription can be found included in common law. And that again, one can turn back earlier in the authorities bundle to the Sunday Times case. And in that case concerned the law of contempt, which, as your lordships will be aware, was certainly then exclusively a common law matter. And at page 28 of the authorities bundle in the first tab, paragraph 47, your lordships will see that the court, or the European Court of Human Rights, observed that the word law is the expression prescribed by law covers not only statute but also unwritten law, albeit, I pause there, it's not really unwritten because common law is of course written. Accordingly, the court does not attach importance here to the fact that contempt of court is a creature of the common law and not of legislation. It would clearly be contrary to the intention of the drafters of the convention to hold that a restriction imposed by virtue of the common law is not prescribed by law. That would unfavourably treat common law jurisdictions such as ours. And so it follows from that, as the Strasbourg court found in Chovy, that it is sufficient for the person who is subject to regulation, especially if he is a professional, as Mr. Adil is, to be able to obtain legal advice about those matters. And I'd also ask your lordships, I can turn your lordships to it if you wish, or I can simply read it. Lord Justice Hoffman, as he then was in the Crown against Central Television, Independent Television PLC, which is in the first volume of the Supplementary Authorities Bond. Probably is as well. We do turn to that. And that's the case in which Lord Justice Hoffman said that the exceptions are exclusive, the exceptions under Article 10.2, and that unless one can rely on it, it's a trump card. But the relevant portion which I wish to rely is at page 43, where at the first top paragraph at module citation A, Lord Justice Hoffman says this: in the area of human rights like freedom of speech, I respectfully doubt the wisdom of creating judge-made exceptions, particularly when they require a judicial balancing of interests. The danger about such exceptions is that judges are tempted to use them. Rather typical Lord Hoffman phrase. The fact of the individual case often seems to demand exceptional treatment because the newspaper's interest in publication seems trivial and the hurt likely to be inflicted very great. Of course, Earl Justice Hoffman was talking about contempt of court. In this case, publication of very unpleasant details in a press report. The interests of the individual litigant and the public interest in the freedom of the press are not easily commensurate. I'm not surprised that in this case the misery of a 5-year-old girl weighed more heavily with Mr. Justice Kirkwood than the television company's freedom to publish material and so on. So it's a cautionary note about the creation of judge-made exceptions. So if I may just summarise my what I say are the 3 points that one can derive from those authorities. For law to be of sufficient clarity, I submit, the statute need not provide for every eventuality, but it must address a particular and identifiable class of expression that is restricted, even if it isn't identifiable only with legal advice.
Do you mind going a bit more slowly?
Of course, my lord, so sorry, and this isn't from my schedule.
It must address a particular
and identifiable class of expression that is restricted, even if it is identifiable only with legal advice. Now, I'm not asking your lordships to take this down in the same way, but to use the example of Chovy, the particular class of expression in that case was defamation. To use the example of Khan, in that case it was reputation too. In other examples, which I'll turn to, it was speech that potentially discriminated against others, which affected their Article 8 rights and their Article 14 rights, and so on. I'll come to that. 2, the second proposition I suggest is that can include common law exceptions, where they might be difficult to identify without the benefit of legal advice. But those common law exceptions must themselves be of sufficient clarity. And 3, a judge might have to refine and distill a pre-existing common law exception, but such an exception cannot be invented, as it cannot have had a sufficient foreseeability or clarity for a professional. And I rely on the cautionary words of Lord Justice Hoffman in that respect. Turning now, if I may, to the application of this case to the Medical Act and case law.
Well, just a minute.
Yes.
Speaking for myself, I, at the moment, take the view that Mr. Justice Swift was right to reject Mr. Ford's argument that the Medical Act on its own is sufficient as an answer to this, that without looking at APC's Guide to Professional Conduct. But so when you said the statute must address, you're really saying, aren't you, the law or the regulation must address?
So it could be the statute, it could be the statutory guidance, or it could be common law.
Yeah,
that's essentially.
So we're looking at the rule that a doctor mustn't do something which would undermine public trust in the profession. And you're saying under this ground that if, which you don't accept, see ground 2, it's ever legitimate to say, to restrict freedom of expression on this basis, you must spell out what expression of views is prohibited.
Yes.
You must spell out in the guidance document.
Yes.
Yes.
And it may, and simply saying, as the Bar Standards Board handbook does, reputation of others, and we'll get back to you on that. The medical grounds, I'd be very surprised if they didn't have a mirror, but on that's sufficient. That doesn't regulate with clarity every single situation, just as in Jalvi in France, the case law, even the case law, presumably wasn't so clear that it covers every eventuality. Obviously, it isn't needed. But there's simply nothing in. So Lord, I addressed this quite extensively in my skeleton argument. The basis on the Medical Act, and perhaps I'll get back to that in reply if that point pursued. But in respect of the guidance, your lordships will see that I deal with that from paragraph 20. Page 24 of the bundle, paragraph 20 of my skeleton argument in this.
Let's just look at this. I again, speaking only for myself, I'm keen that you should get on to ground 2 before long, because that seems to me to be at the heart of it. And if the restriction involved in what's happened here is disproportionate or breach of Article 10 for that reason, then you don't need ground 1. If it isn't, then ground 1 may not get you much further. But
of course, the other way applies also. But
yeah.
And ground 1 is logically precedes ground 2.
I see that.
Sure.
All right, you're referring us to your skeleton.
Yes, if I may, and so the good medical practice, which is the guidance, and the social media guidance, is not undetailed. It's not the most detailed of documents, but nor is it the most undetailed of documents. And it includes, so I've cited specific parts of it. Your responsibility, so for example, the introductory section, paragraph 21(2), professionalism in action, your responsibility to be familiar with the guidance and explanatory guidance that supports it. And then one goes on to domain 1, safety and quality, 3, communication, partnership and teamwork. Nothing in communication about statements of public interest or opinion or anything of that nature. Domain 4, maintaining trust. And that, in my submission, is critical and was relied upon by Mr. Justice Swift. So 65, you must make sure your conduct justifies your patient's trust. 68, and the public, yes, of course, and the public's trust in the profession.
Yes.
68, you must be honest and trustworthy in all your communications with patients and colleagues. And that includes communicating the limits of your knowledge and making reasonable checks. So that is very clearly in respect of patients and colleagues. And the foreseeable meaning of that, in my submission, is quite clearly that when advising a patient about different types of treatment, you must, as a medical professional, provide accurate advice. And of course, the Bolam and Belitho principles apply. That must be a reasonable body of professional opinion. And even if that wasn't there, common law would restrict that anyway. And 69, when communicating publicly, you should remember including speaking or writing to the media, you must maintain public confidentiality. You should remember when using social media, then when communications intended for family and friends may become more widely available. Nothing is foreseeably there directed at the statements of political, scientific or medical opinion or assertions of fact therein. And the social media guidance in my submission takes the GMC no further at all. I've outlined in paragraph 27 what it says: guidance on privacy, benefits of social media, maintaining boundaries between patient and doctor, maintaining confidentiality, respect for colleagues, anonymity, conflicts of interest. It doesn't add anything in my submission that is foreseeably directed upon the expression of an opinion or the expression of facts about scientific matters. Not even in a medical journal, although it doesn't say that either. But in a sort of social media or interview context.
When you say that 68 is restricted to patients,
Yeah.
you interpret patients to mean existing clinical patients, do you, of that particular doctor?
What is foreseeable about, my lord, if I may ask, what is foreseeable about that? Patients and colleagues, the clear limits of your knowledge, reasonable checks, the foreseeable and reasonable construction of that, particularly when it is in contradistinction with 69, which is directly below it and talks about communicating publicly. The foreseeable construction of that, unless a court has already decided otherwise, and that's something on which Mr. Adil could have had advice, the foreseeable consequence is that it affects existing patients, is that it affects advice to patients, advice about treatment, advice more generally. And
so it wouldn't apply to advertising to potential colorectal patients, providing information that there hadn't been reasonable checks to require was accurate.
I can see that it might, because that's clearly, it is reasonably foreseeable that providing inaccurate information to people who may become patients about your expertise.
So it's not limited to existing clinical patients.
I suspect not, but again, one comes back to what is the foreseeable construction of that statutory, in the sense that it's statutory guidance term.
Is it limited to potential patients of the doctor in question as opposed to potential patients of other colleagues?
Not necessarily, perhaps. So, for example, were Mr. Adil to say, I'm an expert in colorectal surgery, but I'm also a paediatrician, and my colleague, Dr. Y, is in Harley Street, for example, is an expert gerontologist, and in fact, his colleague wasn't. That might potentially engage that provision, although
Let's say something a bit simpler. It's simply he's puffing a treatment for something that's nothing to do with colorectal surgery, which he hasn't, as far as he's concerned, been something he's made any reasonable checks to regard as accurate.
No. I go no further than saying it's a matter for another day, and your lordships need not decide it, that it is possible, perhaps, that if one is putting oneself out as a medical doctor and saying that one has an expertise in a particular area, which simply isn't true, that is covered by that provision, albeit I'm sure that there will be other regulatory provisions with more clarity that address that. I perhaps need not find them, but I'm sure that would be the case. But what it doesn't say, and what it's not foreseeable that it says, is that when you're speaking about another area, yes, saying that you're a doctor, I accept that. But speaking about the only real medical matter in this is what Mr. Adil said about vaccines, and vaccines are under development. They weren't recommended for anyone at that stage, they were at a later stage, and so on. It's a controversial area, and I don't hide from the fact that what he said was very, perhaps could be seen as explosive, but nevertheless, that's the only thing that he said about medical matters.
But you say it might be a matter for another day, but all those who are watching the videos are potentially NHS patients in relation to vaccines.
Yeah.
Is that not covered by paragraph 68?
Well,
Where does that take us though, my lord? Because if that is a foreseeable consequence, it's a foreseeable consequence that you as a doctor cannot speak about any medical matter, cannot question research, cannot question the motivations of those who are pursuing vaccines, cannot question, for example, the motivation of pharmaceutical companies, commercial motivation for pursuing vaccines and so on, unless you're speaking within your area of expertise. Firstly, that is an extremely high regulation of the medical profession outside their direct medical practice. But secondly, I submit that is simply not foreseeable. In the foreseeable construction of this statutory provision, I say statutory because it is statutory guidance, is that you be honest in your and trustworthy in your communication with patients and make clear the limits of your knowledge and reasonable checks to patients. That's the foreseeable construction of that. If there was authority, and if there was further guidance to make clear what your lordship makes clear, then that would be a different matter, but it's simply not. And especially when put in contradistinction to communicating publicly, where there is no such guidance. And the way that your lordship puts it, there is no limit to who is a potential patient, particularly when one's talking about something like vaccines, because everyone could potentially be taking them. And that imposes a very considerable restriction. If Mr. Adil had said, as a colorectal surgeon, I recommend this procedure, and that procedure was not compliant with Bolivo, that might be different because it might encourage his own patients. But although but that's not, we're not in that territory, in my suspicion. So his expertise, he didn't misrepresent, it's not suggested that he misrepresented his expertise. It's not suggested that he said he was involved dishonestly. He said he was involved in research and that research was inaccurate. None of those are suggested. It is simply his opinion and the way in which he expressed his opinion that is at issue. So, Lords, if I
Do
may,
you say that we're just focusing on paragraph 65 as
yeah,
as you've quoted it? Do you say conduct can never include the expression of opinion?
of
The expression of opinion by the doctor on any topic.
well, without a sufficiently foreseeable statutory or common law basis for restricting the expression of opinion about medical, scientific and or political matters.
Well, we're
I do
on
say that.
prescribed by law at the moment. On the prescribed by law topic, the paragraph 65 seems to me the critical one. Do you say that the expression of opinion by a doctor is that this provision does not sufficiently spell out that on the GMC's case, the expression of opinion on certain subjects may lead to regulatory action on the grounds that it undermines the public's trust in the profession?
Yes, I do, because and the other examples that the GMC put forward are all based upon a sufficiently clear and foreseeable legal restriction on speech. There's no, so a lot of what Mr. Adil was saying may well be that the majority of people consider they're outlandish conspiracy theories, for example, but they're not actually really nakedly scientific or political. They're perhaps what some people might see an extreme view of geopolitical life and the rationale and the reasons for things, which might be highly controversial, but they are political, expression of political opinions ultimately. The expression of scientific opinions in this case was the expression of an opinion about a developing product that wasn't recommended for use at that stage. And the fact that it might in the future have been is, in my submission, of little relevance. But essentially, these are not sufficient. There is simply not sufficient clarity for a doctor, if that doctor received advice, to understand that he was restricted in what he could say about matters of controversy in those areas.
All right. Well, that is the prescribed by law. Isn't it?
Yeah, it is.
I perhaps I don't need to. I'm aware of the time, but the other examples I perhaps can give you a simple ask you to note the other examples and why I submit that those are examples of sufficient clarity. In fact, you'll see in the in my skeleton arguments in respect of this that I address the examples in the case law of restrictions that might be called restrictions on expression, and you have the references there from page 30 of my skeleton argument, paragraph 42. Dingemans and the BSB, if you read the facts, deeply unpleasant, racist and misogynistic tweets contravening clear guidance about seriously offensive conduct towards third parties. Architects Regulatory Board against Kello, unreported case, but in the bundle it is actually in the certainly in the supplementary bundle. Yes, it's in the main. No, it's in the supplementary authorities bundle, tab 22, from page 447, and that was an architect who essentially said that those from the Jews, Sunni Muslims, and Sikhs were cults and should not have civil rights. So that goes so far in the direction that it is actually contrary to Article 17, for individuals in society. It goes as far as that. Ngoli is a more nuanced and interesting case. Ngoli, you'll see, I have the citations there. In principle, the Court of Appeal found that using uncontextualized biblical quotations about homosexuality could amount to a breach of health and care regulations, council guidance, but only because of express duties to treat everyone equally and not to discriminate. Now, in that case, the Court of Appeal found in Mr. Ngoli's favour on Article 9 grounds, essentially, because this was, of course, his these were his religious views. You'll see the reference there to biblical. And the Court of Appeal observed, you'll see the reference, the previous cases on a restriction of employees or professionals' freedoms of speech have turned on the need to prevent actual discrimination. That simply doesn't occur in this case. Khan and the BSB I've addressed your lordships on already, and the Crown on the application of Pitt and the General Medical Council, which is the authorities bundle, mainly which is bundle tab 11, you'll see an unsuccessful judicial review of the proposed introduction of express duties. So again, if one looks at the parts of the exceptions to Article 10, those affect the rights of others, reputational rights, the rights not to be discriminated against, other convention rights, Article 8 rights, for example, and they also affect reputation. None of them are public health exceptions. There is only one public health exception case in the bundles, in any of them, including as it happens the supplementary bundles, and that's Hurtle. And in that case, as you've seen in terms of ground one, that was a clear prohibition on disparaging other goods, and therefore, unsurprisingly, the Strasbourg Court found that that was a sufficient basis for a foreseeable restriction. So, Mills, I'm aware I've taken up a lot of your lordship's time on developing ground one, but the key question in my submission in summary on that ground is foreseeability. And the lack of any common law authority, the inability of a legal advisor to say to Mr. Adil in 2020, well, we're in a severe pandemic, the government's declared it that, we've got unprecedented restrictions, highly controversial ones, and the government says you must encourage everyone to follow part of that advice. If you don't, or if you disparage in particularly harsh terms the rationale and reasoning for it, or if you raise what others will describe as conspiracy theories, in those circumstances, you could be bringing the reputation of the medical profession into disrepute. That would not be a force. There's no statutory or common law basis in my submission to give that advisor, if advising in 2020, the ability to say to Mr. gone, well, Mr. Adil, sorry, that there is a legal risk of you being disciplined by the GMC for this. And essentially that is the nub of the point.
All right, let's go on to
Yes.
proportionality.
Look at paragraph 44 of my skeleton arguments. I've set out at page 32 of the authorities bundle. I set out the general proportionality principles, which I'm sure will be familiar. I've used the recent force started case because Mr. Justice Chowdhury's judgment is such a good exposition of the principles. And you'll see them. I need not read paragraph 55, but you'll see the freedom of expression is essential foundation of democratic society, paramount guiding principle in assessing beliefs. It is that it is not for the court to inquire into its validity. Clearly an important, particularly important point here. C, the freedom to hold whatever belief one likes goes hand in hand with the state remaining neutral as between competing beliefs, refraining from expressing any judgment as to whether a particular belief is more acceptable than another. And that's the Metropolitan Church of Bessarabia, which is actually now in the supplementary bundle towards the end of volume 2. And the well-known phrase from Redmond Basin, the DPP, cited in by Mr. Justice Knowles in Miller and the College of Policing, not only the inoffensive but the irritating, contentious, eccentric. Now, I accept, for what it is worth, and at the outset, that was a Redmond Basin was a criminal case. Miller concerned a citizen, an ordinary citizen, and those are not directly analogous to a doctor. I accept also that a medical profession may have particular standards it may wish to impose on doctors, and I accept that your lordships will give appropriate but not undue weight to the profession's view of that. But it is important to bear in mind the wording of the convention, which is that firstly that the prescribed by law condition which we dealt with, but secondly that the exception must be necessary in a democratic society. And that, in my submission, is a point that was dealt with with respect by the court below in a backwards way. But the question is whether the interference is permissible given the absence of a specific prohibition, or even if there is a sufficiently clear prohibition. And for it to be permissible, it must be necessary in a democratic society. And there must be an intense focus on that question. And that focus was, if I may say, wholly absent from the tribunal. And it's difficult to discern it from the judgment of Mr. Justice Swift. If I may, a lot of the Strasbourg cases deal with proportionality as well as reasonable foreseeability. And if I may turn back to tab 1, the Sunday Times case, at paragraph 59, which is at page 33 of the authority bundle. Yeah. And the Strasbourg court say that they've already had the occasion to, in handy side, state its understanding of the phrase necessary in a democratic society, the nature of its functionings. And they note that the adjective necessary is not synonymous with indispensable, but neither has it the flexibility of admissible, ordinary, useful. Pressing social need is the way in which the Strasbourg judges put it, and that's been adopted since. And again, in the next tab of that bundle, tab 5 actually, the Chovy case, Chovy in France, at paragraph 63. Page 146. The Strasbourg judges hold that freedom of expression constitutes one of the essential foundations of a democratic society, one of the basic conditions for its progress and each individual's self-fulfilment. Subject to paragraph 2 of Article 10, it is applicable not only to the information of ideas or ideas that are favourably received or regarded as inoffensive, but also those that offend, shock and disturb. As set forth in Article 10, the freedom is subject to exceptions which must, however, be construed strictly, and the need for any restrictions must be established convincingly. That, in my submission, is the nub of the appellant's case in ground 2. Because when one looks back, and I took your lordships to it, the judgment, the findings of the tribunal initially, when one looks back at what the tribunal found, their findings essentially can be summarised in the way that I put it, in paragraph 18, I think, of my Australian argument, which is that they found that because there was, as they put it, an unprecedented public emergency, health emergency, because there was government advice, because people were dependent upon it, because they were expected to comply, their words, with that advice. On that basis, it was appropriate, and I use that word deliberately, to sanction Mr. Adil, and to, it must follow, put out a warning shot across the bows of not only the medical profession but every other profession, that if you dare to criticise government advice in a public health emergency, if you dare express illegitimate opinions, in the words of Mr. Justice Swift, if you dare question the necessity or the appropriateness of medical interventions to it, you are putting at risk the population as a whole, and it is necessary to restrict your opinion. However, the caveat is that they didn't put it in those terms because they never addressed the question of necessity. It was purely an assumption, both by them and by Mr. Justice Swift, if I may say so, that because that public advice was being questioned, because the opinions were, in his words, not legitimate, because they were outraged, because they raised conspiracy theories. What is a conspiracy theory never developed anywhere in these bundles, but one can assume that they mean the Bill Gates, the 5G, and so on. Maybe most people would call those conspiracy theories. It matters not in my submission, because the central element missing from those judgments and findings was a causal link between the restriction and the necessity of the restriction, or any development about why that restriction was necessary. And further, it follows that for there to be a justification for the restriction, it would be necessary for the tribunal and Mr. Justice Swift to balance the risk of unfettered public opinion against, on the one hand, against what Mill put it, how Mill put it, the greatest difference between presuming an opinion to be true, because with every opportunity for contesting it, it has not been refuted, and assuming its truth for the purpose of not permitting its refutation. And of course, there is the fact that that imposes deeply, and in my submission concerningly, on the requirement that the state to be neutral, an established position which reiterated with much force by Mr. Justice Knowles very recently, Mr. Justice Julian Knowles, very recently.
Can I just ask you about this particular case?
Yeah.
Because obviously you're right, in some respects there's some things are not written out, but that was in the context of the appellant's own evidence that he conceded he shouldn't have used his position as a doctor in this way. He'd explained very poor understanding at the time. He'd then gone on to work on the front line himself and knew all about SARS and COVID, etc. And therefore, in some respects, they didn't need to go through that because it was common ground, or is that a misunderstanding of what happened?
It's certainly not a misunderstanding that, faced with Sanction for comments that he made, Mr. Adil certainly did agree that he shouldn't have said them. But I question, well, 2 points really. I question the relevance of that admission because it does not go to necessity. It's simply his opinion. It's simply his response. But secondly, it's an acceptance of the standard that the tribunal was imposing in the context of those restrictions. And frankly, it is really the requirement for an auto de fe. If you don't say that, we're going to sanction you more severely. And we know that this is right because the extent to which Mr. Adil had showed insight was a relevant factor in the sanction. And so essentially the mischief of the way of looking at the tribunal's way of looking at this, the tribunal's approach, was to say, well, because Mr. Adil has accepted under the pressure, under the extreme pressure of his surgical career, has accepted that he did wrong. He shouldn't have said what he did. He shouldn't have given these opinions. Then that is a relevant consideration in deciding whether it's proportionate to sanction him. But he was only doing that because of the way the tribunal approached it.
Is that right? I mean, one of the things of which he was found guilty, if that's the right expression, was saying that the virus did not exist.
Mm.
Now, was he retracting that at the stage before the tribunal only for tactical reasons?
I'm not saying that he was doing anything for tactical reasons. That's not what I'm saying. I'm saying the fact that he has accepted that he should not have said what he said at the very early stage in the pandemic as it happens isn't in and of itself sufficient to establish that it is proportionate to restrict his expression of opinion only to what is an undefined standard of what is legitimate or illegitimate, what is outlandish and so on. And it may well be that he I'm not disputing that he genuinely said, of course I was unwise to say that. I disagree with what I said now. People are entitled to change their mind.
Well, we're looking at something which is fairly binary at the moment in the point I'm raising.
Mm-hmm.
The virus did not exist. Now, I would have thought for myself that when he was saying, I accept that I shouldn't have said that, he was accepting that there was simply no scientific basis for it at all.
Well, one needs to. He was accepting that he shouldn't have said it. I accept that. And he may have come to a different view about the existence of the virus, and that's what he said that he did. But to what extent does that affect the necessity of preventing a doctor from disputing the existence of, in this instance, of a virus in those circumstances? That's the question. Not whether or not he accepts under the pressure of sanction that he has to abide by that standard, which is not the same thing as saying, is to question the sincerity of what he said when he said, I accept it, the virus exists, I accept I should have said it. But the question is whether it is appropriate to take that into account as a justification for the necessity of the restriction, when the necessity of the restriction is a question that should be answered objectively, not subjectively. By necessity, his acceptance of that. It's a subjective acceptance. And indeed, he's not accepting necessarily that it is right to sanction him. He was accepting that he should not have said that, which is a different question. He didn't say, I mean, he wasn't legally represented. Said for most of this, I think he had some legal representation at some time, but until largely wasn't. But irrespective of that, the question of the necessity of a restriction on freedom of expression has to be justified objectively. It has to be justified by considering the necessity. That is to say, the pressing social need of that restriction, and considering that pressing social need, one has to balance not merely the benefit of that restriction, but the considerable disadvantage of restricting opinions and expressions of fact. So I don't resile from that challenge, but in my submission, properly analysed, it really is no more than, well, it really amounts to the reliance of an acceptance of a jurisdiction which objectively is wrong, and that is the jurisdiction to examine and restrict opinion. And the fact that that opinion may be outlandish, the fact that opinion may be considered illegitimate, the fact that that opinion may have been retracted, in my submission, is not a relevant consideration there. It's an objective question. Sorry.
My Lord, I really hesitate, my Lord, to rise to my feet. My Lord, if you keep saying under the pressure of sanction, you may have ascertained from the papers that the doctor did not give evidence. He put in various versions of witness statements and made various comments, unsworn, which are on the transcript. It is evident if one goes, for instance, to page 168 of the bundle and paragraph 90. This is the impairment decision, well before sanction, that the doctor was explaining that he continued to post videos after the commencement of the GMC investigation, and that he deals with certain difficulties and isolation, but says that he will be more careful in future. These things will not be repeated. And then later, when they come to deal with the determination on sanction,
Which page?
167, I was saying. At 172 and 173, you have a full, which is at the sanction stage, in fairness to my learned friend, a fairly full retraction of the matters that he stated so explicitly in the videos. But there's no duress here. This is not as a result of cross-examination. These are statements that he is either making without being sworn as a witness, or that form part of his documentary evidence.
All right. Well, thank you, Mr. Ford. Let's not get too diverted. Speaking for myself, I doubt whether the admission contained in or noted in paragraph 90 of the Tribunal's decision, page 168, is of great significance to the point you're making about proportionality. Can I just go back to two things you said in the course of, it's quite a long paragraph in which you hardly drew breath. The first is, we're considering principally, aren't we, whether the tribunal reached the right decision, not whether Mr. Justice Swift reached the right decision. So you have strongly criticised his use of the word legitimate, but I don't think that was an adjective used by the illegitimate, was an adjective used by the tribunal. The other point I noted in the course of your submissions, were you were saying that these this kind of restriction on freedom of expression to express views on matters of great controversy on a doctor or a member of any other profession.
Mm-hmm.
But part of the case against you, as it were, or against your client, is that this was a doctor identifying himself as a doctor and expressing views on medical topics.
Mhm.
And the tribunal found that the expression of the view that the COVID virus didn't exist, the whole thing was a hoax, would tend to lead members of the public to think that abiding by restrictions was pointless, and thus endanger their health. And as and when a vaccine came along, going to get vaccinated would be pointless as well. And that is part of the case you have to meet. It's not as though he was expressing views on controversial topics where the view of a doctor is, the fact that he's a doctor is neither here nor there. I mean, say a doctor or anybody might express the view currently that, say, President Putin is a wise and noble statesman. It's a view that a lot of people would find repellent, but the fact that the person saying it was a doctor, if he was, is neither here nor there. But the GMC's case against Dr. Adil is that he is saying, I am a doctor, and my view is that the whole thing is a hoax, and this will tend not only to undermine public trust in the profession, but to lead members of the public to endanger their health.
Yep. I have it, my lord. May I answer that in turn? Firstly, I put the case for the appellant squarely addressing exactly what your lordship said, which is that it is quite possible that what Mr. Adil said, and indeed what other people said, might have discouraged people to consider that the restrictions that were being imposed were pointless. And indeed, that is a common opinion that was made by a number of people throughout the pandemic, and it is a political opinion because restrictions are not simply a medical intervention. They are a political decision to impose legal restrictions on individuals. Highly controversial, unprecedented in the manner in which it was restricted, clearly, in my submission, engages a high degree of protection and should do. Moreover, it addresses exactly the point about neutrality, which is that the state, through the organ of the GMC, considered an organ of the state by the convention, is restricting and saying it is necessary to restrict speeches and comments that might lead people to question the wisdom of government advice. That's exactly how they put it. That's exactly the case I am maintaining, Lord. And in my submission, that squarely falls outside what is proportionate to do. It's, in my submission, extremely dangerous. George, and I appreciate your lordship's point that it's about he's a doctor and he clearly used his medical status and medical profession to advance these opinions. There can be no dispute about that. But put the example in a different way. There may well be barristers and solicitors who make extremely controversial points about the appropriateness of a particular legal system, whether or not certain judges have carried on appropriately in the way in which they've dealt with a case, for example, whether there have been miscarriages of justice caused by the legal process. Are those barristers or solicitors to be sanctioned by the BSB for doing so? And when one asks the question, one realises it automatically that if that were to be the case, ultimately, the judges would be determining a case of criticism against them. Now, I of course accept that there will be cases where that could be an appropriate restriction. For example, questioning the personal integrity without any reason of an individual judge. There are examples of that. But in terms of a more general, and that's not what, incidentally, what Mr. Adil was doing, because there are very few references to individuals. As well, Junior pointed out, the only real reference is Bill Gates, but certainly not to medical individuals. The criticism is a global criticism of the system. I accept that certain medical points may accept that point, but generally the criticism is of the process. And in terms of the necessity for it, going back to Lord Justice Popplewell's observation about the denial of the virus,
The way in which the tribunal justify this is because exactly what your lordship said, which is that it may discourage people from following government advice. And that, in my submission, is exactly what a tribunal or a public body such as the GMC should not be doing, because government advice is government advice. Government decisions, including the decision about what to make lawful and what to make unlawful. For example, should cannabis be legal? Should it be legal for medical reasons? Should opiates be legal for medical reasons or otherwise? These are decisions that have medical consequences, severe medical consequences, one might say, highly disputed as to what those will be. Should a doctor not be able to express those opinions? Your lordship will know that many doctors and indeed lawyers and indeed others express opinions on those matters all the time. Where does one draw the line? Because if one is to restrict in this way, no foreseeable basis in my submission, and even if it meets the ground one Article 10.1 and 2 criteria, even if it meets that criteria, the lack of foreseeability in my submission is a very relevant consideration when it comes to proportionality. But if that is the case, if it is necessary in a democratic society to restrict the doctor in what he says about political opinions because of he may discourage people from following government advice, even in what the government describes as an unprecedented pandemic. It wasn't at all an unprecedented pandemic as it happens. I don't think anyone would contend that now, but the restrictions imposed were unprecedented. In those circumstances, that is to engage in a highly political activity and a highly political restriction that goes to the heart and the core of the protection of the court. The courts are obliged to apply to freedom of expression. And it certainly includes advice about medical products. There have been many medical products throughout history that have been extremely dangerous and revealed as such on further inspection. I'm not suggesting for a moment that your lordships can or should decide that that applies here. Of course, that's not your lordship's job. But questioning medical intervention, questioning even the existence perhaps of virus, questioning matters of science is part excellence in my submission, is the paradigm example of the freedom of an individual, including a professional, to examine in the widest sense matters of this nature. It doesn't involve traducing the reputations of others. It doesn't come across the foreseeable restrictions of freedom of expression that there are elsewhere. It doesn't engage what the courts and tribunals have found previously. And if I may come back to the point on which I was being questioned, a person, including a medical profession, has a right to be wrong. It follows from freedom of expression that people may say unwise things, even professionals in the public sphere, that they later regret. That isn't in and of itself an objective justification for restricting their ability to do so, or for finding that it is necessary to do so, to use the words of the convention, in order to protect public health. And I go back to the point that the only justification that is possible to discern from the tribunal for this being necessary is that it undermined the government's advice. The government's advice was incredibly controversial, being examined now in an inquiry. It will be examined in the more general public sphere for decades, if not centuries to come, as is quite proper, and it is wholly improper in my submission for a tribunal, a medical body, or the courts, particularly the courts perhaps, to restrict or the parameters within which a doctor can make that, even though the doctor was indeed talking about medical, scientific matters and political matters that affected those questions.
Can I put one more hypothetical to you and then I'll let you get on? Change the topic slightly. Suppose that a doctor makes video, publishes blogs and so on, saying, I'm a doctor, in my opinion, there is no connection between smoking and cancer. It's a really good idea to smoke at least 20 cigarettes a day, 40 a day would be even better. Now, would the GMC be entitled to bring regulatory proceedings against that doctor?
If that doctor was dishonestly misrepresenting particular medical advice, perhaps, because that goes to the integrity question. It's a speculative question, obviously, and not for good reason, of course, I appreciate. I can think of no examples where something of that nature, a prosecution of that nature, has happened, because there are none. And in fact, there is actually a response to that in the Hurtle case, where very alarming. And I appreciate it's not on the smoking point exactly, but paragraph 51 is perhaps a more general answer. Paragraph 51 of Hurtle, page 89 of the authority statement. The Strasbourg court, again, in the middle of the page, more or less, the court cannot help but note a disparity between that measure, the restriction of to which Mr. Hurtle's put.
I'm so sorry, I can't see where you are. What page?
Paragraph 50, I think, not 51.
So sorry, it is. The disparity creates the second paragraph, fourth paragraph, 50. That disparity creates an impression of imbalance that is materialised by the scope of the injunction in question, and goes on. The effect of the injunction was thus partly to censor the applicant's work and substantially to reduce his ability to put forward in public views that have their place in a public debate whose existence cannot be denied. It matters little that his opinion is a minority one and may appear to be devoid of merit, and I note the word devoid of merit, since in a sphere in which it is unlikely that any certainty exists, it would be particularly unreasonable to restrict freedom of expression. And I know that your lordship used the example of smoking, but where we are discussing a matter that was ongoing, a very recently declared pandemic, where there were a variety of views about its origin and about its causes and so on. And in paragraph 51,
I just want to know
Yes.
how absolute the proposition you contend for is. Because the doctor in the smoking case might say, well, that's my opinion.
Yeah.
Why shouldn't I express it?
he might. And well, again, one goes back to because the nature of the restriction the nature of the justification of the restriction is undermining the reputation of the medical profession. Is it really to be suggested that somebody speaking against the great weight of medical opinion, who is putting forward a very small minority view in that case, if not a minority of one, affects the reputation of the profession simply by contradicting it in an obvious way, when it is obvious to anyone, any reasonable person, that opinion is such a minority one.
The charge would be that the doctor undermines trust in the profession and does so in a way which will tend to encourage people who believe him to make themselves ill.
And it's a specific example, my honour, if I may say so, which relates directly to smoking.
Yeah.
And I accept that your lordship is testing how far I suggest that this should go, but one doesn't, in my submission, your lordships do not need to test that here. And if I may say so, the problem about hypotheticals is that they are hypotheticals, and that's why your lordships decide on cases on their individual factual merits. And in this case, the way in which, and I go back to the point, it's not simply the desirability of the restriction. It is not simply the fact that there is a widespread, if not almost universal view, well, I don't necessarily put it as high about that there was a virus, the causation of the pandemic. It's simply that the question is, for your lordships, is the necessity of the restriction. And the way in which your lordship put it just now was undermining the possibility that people will follow government advice is absolutely right. And that's government advice about restrictions and government advice about the way they should approach things. Well, that advice was highly controversial and was quasi-political, partly medical, partly political, because it entailed decisions about public policy that are matters of high controversy.
But he wasn't commenting really about whether they should be following advice. He was making assertions about whether it existed.
Yes, he was. But
And the experience of media cases is that very often newspapers come and defend an article they didn't write. And so it's probably better to concentrate on what he did say rather than what he might have said.
well, that's my point, Malone, which is that he did say it, and the question that is posed is it necessary for the benefit of public health to restrict his ability to say that, his ability to make even outlandish comments that might be seen as outlandish by others about scientific, medical and political matters, when the tribunal's justification is frankly tissue thin, other than that they said they have found as a matter of fact that it had a tendency to undermine the compliance with government advice. And it's that is the way in which they put it. Now, I appreciate that, as Mr. Justice Swift put it, that your lordships will focus on the outcome rather than the process. But the process by which the tribunal got to that decision is actually really important, more important, if I may say so, than it was suggested in the High Court, or found in the High Court, because that is the justification. That is the way in which this restriction, this exception, is justified by the tribunal on the basis of undermining government advice. They didn't focus on the fact that Mr. Adil, I mean, of course they made findings about Mr. Adil having denied that the virus existed, but when they were justifying, when they were doing what they had to do to be compliant with Article 10, they had to examine, although they didn't address the question in this way, they should have done, they had to examine necessity, and that is to say pressing social need for a restriction. And if they were to do so, and they were to say and find that it is necessary to restrict doctors who may undermine government advice, that is far, far wider in consequence than as it applied to Mr. Adil.
They didn't say it's necessary because it's contrary to government advice. They said that it's misconduct because, in our professional view, as a medical tribunal, it was likely to harm members of the public.
But why was it harming medical members of the public other than by not encouraging them not to follow government advice?
Well, because the tribunal spelt out, because denying the existence of the disease would, for example, cause them to pay no regard at all to any benefits of distancing.
Yes, government advice.
Well, that may have been the government's advice, but that doesn't preclude the fact that it was also the view of this professional tribunal that it was the correct advice from a medical point of view, because the tribunal thought that not distancing in a way that people who thought there simply was no disease would behave. It's not a question of how much distancing or whether to wear a mask. If you say to people, there is no disease, you should, they're likely to think, well, I can just behave as I would without any form of seeking to adjust my behaviour. And the tribunal found that, in their view, that was likely to harm members of the public. And that's not the tribunal's view that it's wrong because it goes against the government's advice. And the fact that there was government advice in relation to social distancing is not itself part of their process of reasoning, is it?
It is, in my submission, a very important part of their reasoning.
the tribunal started by expressing the background, the factual background. I think it's in the findings of fact. If I may just have a moment to find where this was done. The findings of impairment and the findings of fact are an important part of the process by which they analyse.
Is it paragraph 53 of the sanction determination? Maybe in the earlier passage.
Which page? Yes, it is. That is where they justify the restriction. But the restriction on Mr. Adil. And your lordship is correct that is exactly the mischief to which they were directing themselves. But that is a commentary on what is not simply a medical matter, but what is a matter of government societal reaction to violence and the appropriateness of that reaction. And the necessity was justified in terms, as your lordship put it, that it will discourage, it could have the effect of discouraging people to follow government advice. And the government advice may be thought by the profession to be right, but that again is not and should not be the question for the tribunal, because the advice was by its nature political in its derivation, and the fact that it was given by medical professionals such as Professor Whitty, for example, does not, in my submission, and should not hide that these are political decisions made by politicians to advise and to put Professor Whitty on everyone's television screens at 5 o'clock every day to dominate the agenda with his and others' views. These are, by their nature, political acts by the government, political decisions as to what should be done. And your lordship is right to say that it is not suggested that Mr. Adil was saying take or do not take particular medication. I appreciate he mentioned, he certainly did criticise the vaccine, but the vaccine hadn't been developed at that time. That the effect, the mischief to which the tribunal's attention was directed was the effect that his comments may have on the compliance, which was their term, of the public with medical advice. And if that is a sufficient justification, it would justify any form of debate, potentially, that justified that, including political and non-medical objections, including from the libertarian or the conservative or liberal point of view to the very existence of lockdowns, the very existence of the government advising people as to what to do, which is a position, it's a political position, might be a very small minority political position, but it is a political position, because ultimately these are, in my submission, political decisions that Mr. Adil was, had the effect of which, of Mr. Adil's remarks, had the effect of, according to the tribunal, of causing people to doubt and question and not obey political commands. So that's why it engages.
You've made that point, Mr. Hall, right? And I'm a bit concerned that in this one-day case we're at 1:45, and you've got ground 3 to come. But what else would you like to say on ground 2?
If I may, I think your lordship, I've addressed your lordships at some length on the necessity in a democratic society point.
Yes.
My lord, your lordship has my submissions on in my skeleton argument on the inappropriateness of what I submit as the inappropriateness of an equivalent of the Boland-Bolitho test, which is it's at ground 4.
Your paragraph 57.
Paragraph 57 and
Yes.
And so on. And the high threshold in respect of disciplinary thresholds, and where what
category of behaviour this is, may I take your lordships to the remedy case, which is in the authorities bundle at page 166.
Main authorities or supplementary?
Main authorities.
Tab 6.
Thank you. I didn't have that somehow. And I won't go through that as a whole, but I'd ask your lordship to have regard to that. And essentially, there are the question is, to what extent is this the conduct of a medical professional, and that is is this professional misconduct? Professional misconduct can there's obviously a scale of professional misconduct from direct activities in a medical professional's practice, such as the way in which he treats patients, gives advice to patients on the one hand, and on the other hand, matters wholly disconnected from his medical practice, but might have cause to trouble the regulators if it is particularly serious or disgraceful conduct. And there is a question to be asked in my submission as to where on that scale Mr. Adil's conduct fell, and a question as to where it fell with regard to the behaviour affecting his fitness to practice. Now, of course, it is right to say that Mr. Adil did say he was a medical doctor, he's a surgeon, did rely upon that. And therefore I accept that he is somewhere towards the middle, perhaps, of that spectrum. But nevertheless, he was not giving, for example, the authorities relied upon include, in reference, in remedy, the Meadows example, case of Roy Meadows, who was giving evidence to an expert tribunal, include the Roylance example, which I think is another case of a doctor giving expert evidence. Those in my submission.
I think acting in an executive capacity.
And that was another acting in an executive capacity. And remedy was the question of whether or not Sir Liam Donaldson, who was again at that time the chief medical officer, could be guilty of misconduct for his actions in an executive capacity, and there are others. Those in my submission fall more closely towards the misconduct within practice than giving an interview to a non-medical practitioner on social media. I accept that they do potentially engage the regulator. That in itself isn't a reason to say that they don't. But there is a question as to the extent to which, in making videos of that nature, they affect his fitness to practice, when there is no question of his fitness to practice as a surgeon. His surgical ability is not there's not questioned in this ground. Now, that obviously is only I put it as your lordship's fourth consideration, because of course it's not determinative, but it is in my submission a matter to consider, and I would ask you to take into account where this falls within that spectrum, and the extent to which his behaviour must be particularly dishonourable, as the authorities put it, to fall within an area where it should be regulated. Lords, I think unless your lordships have any questions about more questions about ground 2.
Let's move on to ground 3. Yes.
In respect of ground 3.
Just pick it up in your scan.
Yeah, indeed. So sorry. At that point, I had failed to identify my Lord Justice Dingemans' judgment in Canberra, which isn't there. But if I may turn to that first, actually, which is at tab 10. And I'll I will turn in due course to the length of the suspension and the nature of the penalty as compared to with other cases, which while every case is different, are not entirely irrelevant. But Mr. Justice Swift did not accept that he could have any regard to previous time served on a suspension. And in my submission, that in making that decision, he was wrong, and he made the mistake that I suggested that this was, which was this. This is a different professional body. It's the Nursing and Midwifery Council, but they have a similar provision to the provision in good medical practice and the statutory guidance given to the tribunal, which is that the tribunal making a final finding should have limited weight, give limited weight, if any, to findings of an interim tribunal. And as the Lord Justice Dingemans identified, the reason for that, paragraph 36 at page 231 of the main authorities bundle, the reason for that was paragraph 36. It seems that the guidance was directed to ensuring that panels did not take an unduly harsh view of a registrant simply because they had been subject of an interim order. I say that because paragraph 31 noted that an ISO might be relevant, an interim suspension order might be relevant, and a registrant might say that they had had insufficient time to remedy defects in practice. However, there was nothing in the guidance to suggest that registrants who might have spent up to 18 months, and on some occasions over 18 months suspended before their disciplinary hearing, should not have that period of time taken into account as a relevant factor by the committee when determining a proportionate sanction. And it is simply that point that is really enlarges a point upon Mr. Justice Lewis's or his judgment in Poole and the GMC, which you'll see underlined at paragraphs 45 and 50 of that judgment of paragraph 62 of my Skeleton argument, which is essentially the judgment, the sanction must be proportionate, and in deciding the proportionality of the sanction, it's appropriate to take into account the period within which a doctor has already been suspended or another professional, and there is no reason not to apply that judgment to very similar provisions in this case. I put it more. I did address this in the High Court. The other point that seems to be addressed in good medical practice is that a tribunal should not have any regards to interim findings of fact, and that's obviously right, and should not have any regard to the seriousness with which the interim tribunal found a particular transgression. And that also is obviously right. And it's for that reason, it seems to me, applying that in a proportionate way that, or I submit, that it's in that way that should be treated. And therefore it is appropriate to have regard to the very extensive, and it's well over 18 months in total. Your Lordships are aware that Mr. Adil's spent over a year, well over a year suspended in the run-up to this appeal, and also that he will spend a year, if your Lordships do not alter the sanction, a further year suspended. Your Lordships have the general.
Why would he spend a further year? I thought the sanction was 6 months.
6 months, further 6 months. I'm so sorry. Yeah, I'm so sorry. Well, 6 months indeed. Which is what it would appear the tribunal and Mr. Justice Swift considered to be an appropriate sanction. If that is an appropriate sanction,
And if the logic of your lordship's findings in Rover are to be upheld, then it would be appropriate, in my submission, not to punish Mr. Adil further, because the sanction is for this transgression, if that is what it is found, and that would not have the effect of suggesting, if your lordship's found that 6 months was appropriate, it would not have the effect of suggesting to other tribunals that the Court of Appeal had endorsed that as an appropriate sanction, because your lordships can say in your lordship's findings that but for the period within which Mr. Adil had already been suspended, your lordships would have imposed a different sanction, and it is open to your lordships to overturn that sanction with that form of reasoning. And that would not be a precedent that your lordships would not want, if your lordships found 6 months was appropriate, would not want to impose. Now, I do, however, suggest that the 6-month penalty is disproportionate. I do ask your lordships, and I think we dealt with this before at the beginning of my submissions, I do ask your lordships to take into account, and perhaps I'll come back to Lord Justice Popplewell's point about proportionality. And essentially the answer is this: proportionality of sanction. The extent to which a doctor might be punished for stating an opinion and for exercising his Article 10 rights, even if a tribunal found that it was appropriate to sanction him for it because of the engagement of an exception, whether it be public health, reputation or otherwise, does not mean that the nature of the sanction does not have an additional effect, because there may well be cases where doctors, including on receiving advice, will be unaware to a fixity of whether their statements might or might not transgress boundaries, even if they are couched with sufficient foreseeability. And consequently, a much higher sanction, a disproportionate sanction, would have a chilling effect on the exercise by professionals, in this case medical professionals, of their freedom of speech. And it's for that reason that I submit that proportionality is appropriate. But I also ask your lordship to bear in mind, as a comparator only, and I accept, of course, comparative cases, as your colleagues in the Court of Criminal Appeal have said on many occasions, are only of limited use, but they're not of irrelevant use when they have been, particularly when the High Court has changed the sanction to a particular sanction that it considers to be proportionate. In the Khan case, the Bar Standards Board case of Khan, a 7-month suspension was found to be clearly excessive. For your lordships have heard and seen the facts in that case. That was, in my submission, serious conduct in which the integrity of another barrister was traduced, and in which confidential legal proceedings were revealed in roving room gossip. Dingemans was a case in which a £1,000 fine was found to be an appropriate sanction for what was, on any view, and your lordships can turn in pupils to that if you wish to see the severity of it, grossly racist and sexist tweets. And Poole, 3 months was not disproportionate for giving expert evidence in a field in which Mr. Poole was not an expert. Well, firstly, that is much closer to the type of activity that falls squarely within a medical practice, giving evidence as an expert, than does giving a talk, albeit he's saying one is a doctor, in a public forum. And secondly, in my submission, that is a very serious act of professional misconduct, giving evidence of, because it could have a direct effect on the outcome of a particular trial. And it goes directly to the confidence within which the medical profession should be seen. And so in my submission, 6 months is excessive, but even if your lordships are against me on that, I submit that it would be appropriate to find that there should be no further period of suspension because of the least 18 months, I think,
and we'll get the correct figure and we'll agree it, I'm sure, on which, as a consequence directly of these interim suspensions, Mr. Adil has been suspended from medical practice. And that might be a convenient moment when it's
Yes,
those are my submissions.
those are your submissions on ground 3.
I'd hope to finish at half past to give the learned friend more time.
I had hoped that you would finish at 1 o'clock and it's 1 minute to 1.
Well, I'm grateful. Thank you.
Thank you very much. We'll rise to 2 o'clock.